Good afternoon and welcome into Legal Access. We get together each and every Thursday at this time to give you access to the law and different aspects of it. Today we're going to be talking about personal injury. Now, personal injury envelops a lot of different things, mainly car wrecks, if you have a slip and fall accident, if you've been hurt at work. All those things are fair game here today. Make sure and give us a call. Phone number's on your screen, 843-848-8080. Give us a call over the next 30 minutes. We'll get you on the air here and get those questions answered. To answer those questions on the panel today from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
And also welcome back. It's been a while to Joe Sandifer.
Great to be back.
Great to have Joe with us. Joe's with Morgan & Morgan, does an outstanding job, excellent trial attorney, and tell us where your office is down. It's on the south end.
Right, so our office is in Murrells Inlet, and then we have offices obviously other parts of the state as well, but we practice here in Murrells Inlet, which covers Myrtle Beach and the general greater Myrtle Beach area.
And as I said, Joe does a great job, and you know, there's a personal injury show which encompasses a lot of things. We always think of car wrecks, slip and falls, you know, sometimes nursing home malpractice, products liability, right? And you're obviously your firm does all those things and more.
We do, that's right.
And so if you have any questions regarding those topics, you can give us a call today, 843-848-8080. Right, Dave? And I don't know, Dave, where you want to start?
Well, we've had a couple of incidents here recently. I know it might fall under premises liability, but that's kind of under the same umbrella. We've had a couple of incidents recently where people have had accidents or people have been injured or even killed in some of our pools at some of the resorts in the Myrtle Beach area. Now, even though if the pool puts up a sign that says no lifeguard on duty, swim at your own risk, does that exonerate them from any kind of liability?
Well, as they all are, right? It's fact specific,
Really
and it depends on what duties does the pool owner have. If they don't have a lifeguard, then obviously they haven't assumed the duty to provide one. But there's a lot of codes and requirements that the pool still has to meet to keep it reasonably safe. Life-saving devices, proper measurements of what the depth is of the pool. And then a lot of times, what are the chemicals that they're using in the pool for things like that. So so just to swim at your own risk, I don't think gets rid of all of their liability, but it could alleviate some for sure.
Yeah, it certainly gives them something to argue about, and maybe legitimately argue about. But it's you know, when you're making profit off premises, you sort of have a duty to foresee that there may be risk of danger, and then what do you do to lessen that danger? And as Joe said, it really comes down to a case by case. And I know people roll their eyes when lawyers say that because it seems like something a lawyer would say, right? That's what we joke, but really it does come down to case by case. You know, it's always going to be safer, you would think, if you have a lifeguard, if you know that there's going to be children on the premises. You know, frankly, what happens in these cases, it seems, is, you know, that if it's a child, what is the premises, you know, lawyers will point probably to the guardians or the parents, and, and you know, but as a defense. So you just have to really look at the facts, and it's really depends on the case. But what everybody would agree with is you know, especially when it's a child, that we should do everything we can to prevent that from happening.
As far as pools are concerned, I know this is also in the premises liability range, but as far as like private pools are concerned, not resort pools, do people have responsibilities of putting fences up? Is that a law in South Carolina that you have to have a fence up around your own pool to protect the neighborhood from any kind of accidents?
I believe it is.
Yeah, there's a code, and you know, and we talk about it all the time. Attractive nuisance. You know, anytime you have something on your premises where a child might be attracted to, and you know, that attraction can lead to injury, there's going to be some duty to take steps, and so yeah, you know, you'd want to have a fence, you want to have signs, you'd want to really do whatever you can to protect children. Right.
The phone number is on your screen if you have any kind of questions about personal injury cases. 848-8080 is the phone number. We've had a lot of rain through the course of the day and more on the way. Make sure and keep it right here on WMBF News for all the latest on some of the storms over the next couple of days. If somebody walks into a store and there's either water around the front door where they're walking into, or there's, unfortunately there's a leak in the ceiling and you see buckets all around and you see little puddles, you slip on something and you fall. Does that, even if they put a sign up that says slippery when wet, please watch your step, what kind of situation are we in there legally?
Well, again, fact specific, but typically the store or the property, the commercial property that you're going to, they've got the responsibility to keep that property in a reasonable, safe condition, right? So if you're talking about a slip and fall incident where there's a puddle on the water, or excuse me, a puddle on the floor, it's going to come down to how long has that puddle been there, and who created it, who left that puddle, and has it been there long enough for the employees of the store to locate it and address it, either by cleaning it or warning of it. So a lot of the cases that we look at with slip and falls in a grocery store or a big box store is we have to find out, okay, how long has this been there? Because if the customer right before you spilled their water and didn't tell anybody about it, well, that's not on the store. They had no opportunity to find it and clean it up.
I guess the argument could be made that if you had enough time to go put a sign out that says, watch out, this is going to be slippery, then you've had enough time to know that there's a problem.
Yeah, and what's interesting about those cases is there's case law that both sides can use as artillery to argue their case, and more so to me than a lot of areas of law. It's there's Joe quoted right from a case when he said the reasonableness, and then there's a case where it says the premise is not the insurer of people's safety, but then there's language on both sides, but Joe's absolutely right. It's reasonable. We've said it on the show many times that word is really what it comes down to in most of these cases.
Yeah, absolutely.
And we talked about swimming pools and resort pools earlier on the show if you're just tuning in. Now, along the same lines, we have a lot of amusements along the Grand Strand. If somebody's going to a ball game or somebody's going out on parasailing or on a banana boat and they sign a release, a waiver before they go out, and they still get injured despite signing the waiver, have they signed away their rights?
Potentially, yeah. And again, it's going to depend on the language of the waiver and what risks is that patron assuming, and what liabilities is the proprietor actually waiving. So it's very specific on that exact language, that we do have some case law in that area.
And they can't waive gross negligence, right? So if somebody ever has a case like that, I would just, especially if you have significant injuries, sit down with an attorney that does that type of work, like our firms do, both of our firms, and a lot of other good firms that do it as well, and they'll sit down with you for no cost and go over your case, and it's just smart to do that, because just because you signed a waiver is not necessarily prohibit your ability to go forward. It may or may limit it, but it's something that you want an attorney to look at.
And going back to slip and fall accidents for just a second before we head off to a break, just because you have slipped and fell in an establishment does not mean automatically that you have some sort of a case against that establishment. That's
correct. Right. The property owner is not the insurer of your safety. Comes back down to what Ian was saying about reasonable, was it in a reasonably safe condition?
And just because you might not want to bring a case against somebody doesn't mean that they might not be on the hook, or at least they might be able to help you out with your medical expenses.
Yeah, most premises companies, whatever you want, are going to have a no-fault policy. So that's something to look into, even if you don't think you can prove that they were negligent. Just the fact that you were on their premises and you were injured, you might be able to get money to cover medical bills and potentially even lost wages.
Tell you what, we're going to run to a break here real quick. I know we have a couple of calls on hold. If you're on hold, please stay with us. We'll be back in about 90 seconds. We'll get you on the air and get your questions answered as we're talking about personal injury here today. That's our topic here on Legal Access. Welcome back. It's Legal Access. We're talking about personal injury today, car wrecks, slip and fall accidents. If you've been hurt at work, those are all fair game here today. Give us a call. The phone number's on your screen if you'd like to get your questions answered here today. 843-848-8080. Do have a couple of people on hold that have been kind enough to hold on through the breaks. Let's go to Andrew first off in Myrtle Beach. Andrew, thanks for hanging on. What's your question for the panel today?
Recently went to have blood drawn, and the phlebotomist, when they put the needle in, actually went too far and hit a nerve, and it felt like lightning went down through my arm. And I said something immediately, and they didn't stop drawing the blood. They continued, just moved the needle around, and they said, oh, I must have hit a nerve. Ever since that happened, I've had tingling right on the end of the nerve where it meets down in your thumb and your pointer finger, and then also where the injection happened. Now I'm starting to get a little bit of pain in that same spot. It's probably been, I don't know, maybe 2 weeks now, but didn't think much of it, but it's becoming a recurring pain. What do you think happens here?
Yeah, let me start by asking, did this occur in South Carolina? Just so.
I don't know if he's still with us. Just let's assume.
Yeah, let's
that it
assume
is.
it's South Carolina. But what I think we both suggest is that you sit down with an attorney. Don't wait too long. There's different statute of limitations depending on the case. But let's talk generally, and again, I'll just say that I would definitely, if you're having recurring problems that is not going away and you think it's going to be permanent in nature, it would be smart to sit down with a medical malpractice attorney. There's attorneys, and that's all they do is medical malpractice, and I would encourage you to do that. But generally speaking, let's just talk about med-mal and
Sure.
standard of care maybe. And
Right. I mean, that's going to be the first question. If someone were to come to me and bring this type of scenario, is find out, well, what is the standard of care for a phlebotomist? Meaning, how are they supposed to draw blood? It usually takes talking to an expert in the field who tells you how it's supposed to be done. And then you compare that with how did this phlebotomist do it?
Yeah.
And if they deviated or didn't follow that standard, then you can move on to the next step potentially of investigating the claim.
yeah, and you mentioned an expert, and in South Carolina, for any kind of medical malpractice or really any kind of malpractice where you have a professional, you need an expert, right?
Right.
To even get you,
Right.
let's just say,
Yeah.
to even initiate the claim. And really from a practical standpoint, you'd want that anyway. But I'll just say, and I'm not commenting on this caller's case because we really need a lot more information before we can do that. But generally speaking, medical malpractice cases are very, the attorneys that all they do is medical malpractice, they'll tell you,
Right.
Out of every 50 or 100 that come in, we might take
Right.
1 or 2 or 3. And there are things that you might go, wow, that's definitely a case.
Right.
But the point is, they are not easy cases. They're
Right.
expensive to
Yeah.
go forward with. And in fairness, the laws, to an extent, are designed to protect. I mean, it's an inexact science.
Right.
There's times when things just are going to happen when
Yep.
you have a certain procedure, and I think the law provides for that, and we don't want all these people
Right.
in the medical field that are working hard. And again, I'm not commenting on that case.
Right.
Right.
Generally speaking, the process is that we, that they're really sort of egregious cases, right?
Right.
Joe, is that fair?
Right.
Yeah, Andrew, if nothing else, if you get in touch with somebody who does personal injury, they'll probably be able to point you in the right direction because there are so few people who do exclusively medical malpractice, but that's somebody who you'll need to go to. So you might need to make a couple of phone calls to need to go to where you need to be and find out whether or not you do have a case. But Andrew, thanks for
yeah.
calling in, and sorry about your situation.
Yeah.
Very sorry about your situation. That's scary when you have
Yeah.
start having nerve issues.
Right.
Something as
Absolutely.
common as getting a blood draw, you wouldn't assume
Right.
something like that
You
goes.
shouldn't have that. So hopefully, number one, that you'll get some relief, physical relief, and
Right.
take care of that itself. But if not, And if it goes on, I would sit down with
Yeah.
somebody.
Right.
100%.
Good luck, Andrew. Thanks for calling in. Let's go to Murrells Inlet now. Marianne's been holding very patiently. Hi, Marianne. What's your question today?
Hi. 4 weeks ago, I slipped on a blueberry in the produce section of a very big chain store. My right leg went out from under me, and my left knee impacted with the concrete floor. And finally, store personnel came around and took pictures and filled out accident reports. And it looked like it had been there a while because there were several blueberries smashed and cart tracks going through it. And so I was told that if I sought medical help, I should tell them to contact that store. It was in North Carolina, and that, you know, they had the accident report filed there. And there wasn't. I went to the ER in that town, and there was nothing broken, but it was swollen, and it's still painful 4 weeks out. And I'm wondering, what should my next step be? And if I get a lawyer, should it be one in North Carolina or a local one in that area?
Yeah, if you don't, if it's a North Carolina case, the laws in North and South Carolina, even though we're contiguous states, the laws are actually in these type of cases have a major difference, and
Yes.
that is in North Carolina, if the plaintiff is found to be even 1% at fault, technically they could be barred from any compensation. Right. It's called contributory negligence. In South Carolina, we have laws that are much more fair and favorable
Right.
to an injured person. And it's called comparative negligence, where if the jury deemed the injured person to be 1% or 20% or whatever, anything less than 50% at fault, they're just going to have that amount deducted from any award. Where in North Carolina, it's a complete bar, even if you're 1% at fault. So I'm not trying to tell you not to follow up on this, because I absolutely would. Yes, you should get a North Carolina. It was somebody with a North Carolina license. I think it'd be a good idea to have somebody close to the area where this incident happened. I'm very sorry that it happened. If it was in South Carolina, we would say, wow, if the incident seems like, you know, you had blueberries that were there for a period of time and your injuries were serious, you know, I would definitely sit down with an attorney, because you probably have a viable case. Joe, what should we add?
100%. I think we had cases in law school with the banana peel,
Yeah.
and it came down to how long had that banana peel been there. Was it bright yellow, meaning that it hadn't been there for very long, or was it brown and smushed and had obviously been there for quite some time? So the same issue is going to apply, Marianne, with your case, is are you able to show that those blueberries had been there for a significant amount of time? The good news is a lot of these big box stores have cameras, so
Right.
a lot of times you can find out. You just get the video if you can, and it'll tell you.
And that's a great point, Joe, and that's why you would want to get an attorney sooner than later, so you can preserve that information if it's on video. A lot of times after 30 or 60 days, he'll say, oh, we get rid of it. That's what we just do in the course. So I would, if I didn't have an attorney, I would at least put him on notice of that, so they don't get rid of any potential
Right.
evidence. And, you know, just because it is in North Carolina, if you didn't do anything that could be deemed at fault, then
Right.
you would have a
Right.
claim. So I would talk to a North Carolina attorney as soon as you can, especially if your injuries are ongoing.
Right.
And finally, we talked about earlier, Dave, at the very least, if you have medical bills and you don't think, and your injuries don't seem to be permanent, you feel okay in a couple of weeks, then you might want to see if there's a no-fault insurance. If it's a big company, they probably will, and you can at least get those bills paid.
And most personal injury attorneys will give free consultations. So, Marianne, it shouldn't cost you anything to call an attorney somewhere in the area where you fell in North Carolina and at least get an opinion on that.
Yep.
All right, before we go to a break here, let's go to Longs right now. Mary is on with us. Hi, Mary. Thanks for calling in today. What's your question?
I just have a general question. I was sent to the ER by my physician on the day that I was seen, and by an ambulance. And when I got to the ER, they made me stay in a chair the entire time, and I was worried about COVID. I had asked them about giving me a mask and all of this, or if I could be put in a room. They did not. I actually got COVID while I was there, and they did not treat me promptly. I'm trying to find out if there's anything that I can do to, like, help recover my bill. My insurance paid a portion of it, but then there's still some left. I've requested my records 3 times, and they will not forward me my records.
What do you think?
Well, a couple things. I think the records issue, looking at the last issue first, is that they should give you your medical records. You have a right to they're your records, and they should give them to you. So I would stay on them about that. COVID, well, this is kind of a mixture of a potentially medical malpractice and COVID, and when you put those two together, it gets very, very complicated. Obviously, I think there were some special laws enacted with COVID and what the liabilities would be related to that. I think it would be, you're going to have to talk to somebody who really focuses in on those types of issues.
Yeah, and there are attorneys that really got in and honed in on the laws and COVID cases, and I hope for your sake that you don't have any long-term issues from it.
Right.
And but if not, you might want to write a letter to the powers that be at the hospital and explain it and say, you know, I got these bills as a direct result. You know, I don't think it was reasonable, and I mean that's a
Yeah.
And if it's just a matter of getting your bills paid, that might be a way to handle it. But if you have more serious issues from this, and I certainly hope you don't, but then I would look online, because there are attorneys that did handle those type of cases and got really into the nitty-gritty of dealing with
Right.
those.
Mary, good luck and thanks for calling. Appreciate that. We're going to have to throw to a break here real quick. We'll be back for just a couple more minutes as we talk about personal injury here today on Legal Access. Stay there. Welcome back to Legal Access. We're talking about personal injury here today, basically talking about car wrecks, hurt and fall, slip and fall, hurt at work situations, any of that kind of stuff. We don't have a whole lot of time left to be able to take any phone calls right now, but as we finish things up here today with our panel, Ian McGuire and Joe Sandifer, if you get hurt in somebody else's premises, like on somebody else in a business, and you slip and fall, what's the first thing that you need to do? You need to contact the manager on duty?
You need to make sure that there's some form of notice, or that you give the property owner some form of notice that you've had an incident or been hurt, because that will trigger them to preserve certain pieces of evidence, namely in these big box stores, the videos, because they don't have to keep those videos forever, and sometimes that can be your best piece of evidence.
And in the last 30 seconds we have, since we're talking about car wrecks, we haven't done a lot with car accidents. I've asked a lot of other people over the years, but you get into a car accident, your parents always said, or the person comes up to you and says, hey, we just had a fender bender. Let's just exchange information. Don't have to get the cops involved. What's your suggestion on that?
You should probably go ahead and let the authorities know and have them come out and do an official report. Just keep it all above board, and then there's a record of it.
That seems to be the consensus. Thanks to everybody watching us here on Legal Access. Tell you what, for the next couple of weeks, you won't be seeing us here on Thursday afternoons because of Olympic coverage, but we'll be back in a couple of weeks after that, and hopefully we'll see you then. But each and every Thursday afternoon at 12:30, 30 minutes for your access to the law. That's why it's called Legal Access. I want to thank our panel here today, Ian McGuire from the McGuire Law Firm, and also Joe Sandifer from Morgan & Morgan.
Thank you.
I'm Dave Priest. We'll see you again in a couple of weeks. Again, not next Thursday because of Olympic coverage. In the meantime, if you have any questions about the weather going on for the next couple of days, keep it right here on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.